Folks, you're watching the Law and Crime Network. We've lost a feed from the courtroom in Iowa. We apologize that this has taken us a while to get up to speed on this case. We're going to try to get it back to you any second now, but we're following the case of Larry Whaley. This is an Iowa defendant who's facing second-degree murder charges related to a shooting through his door, as I understand it, which wounded and ultimately killed the victim, who you're looking at right there. Adam Sostrin is an attorney in California. He's joining us for a little bit of analysis here. Adam, it's good to see you back here on Law and Crime. This time you are 3 time zones away from us, as opposed to the last time when you were sitting right here.
I am, and I'm so much warmer. I just had to turn on the air conditioning.
Oh, gee. Well, you know, we do run the air conditioning in the studio because it gets kind of warm in here under the lights. So, but it is still cold outside. So we're trying to get up to speed on this case. We've been paying attention to things all day. We've had some cell phone testimony up this afternoon. Not a lot of really exciting stuff, but we do know that this was a case that dropped from a first-degree murder charge down to a second-degree murder charge. Right. And we were talking earlier that in Iowa, the second-degree murder charge is sort of the catch-all that encompasses a lot of stuff, whereas the first-degree murder charge wouldn't catch everything, and that's apparently why the prosecutor dropped the charge down.
Sure. Well, it's so much easier, and in most of the jurisdictions in this country, when they don't just have everything they need, often they throw away that first-degree charge out, and then they'll charge a second degree. So pretty common for something like this to occur. It doesn't look like there was any specific motive with regard to the victim in the hallway in this instance. I guess it was my understanding he believed that perhaps people have been trying to potentially break into his apartment, and it didn't involve this specific victim.
Yeah, you know, I mean, I look at this at first blush and say, as a society, have we turned into a collection of people who, when we hear sounds outside our doors, our first reaction is to just pull a weapon and start pumping the door full of lead? Because we've got this case, we've had other cases that are similar to this. You know, is it reasonable to react that way? I would argue it's not, and now we have cases like this that are popping up around the country.
Well, and that's sort of how the defense can deal with the, or the prosecutor can deal with these kind of cases where you can sort of get an imperfect self-defense claim where the action isn't reasonable, although the person subjectively believed that they were going to be attacked. So it being imperfect, it's not an absolute defense to the charge, but it's enough for a person to get a conviction and a number of years in state prison for, and it's something that the defense often shoots for because, well, it helps their client. They do less time.
Yeah, I mean, how would this play out from a defense standpoint? Because I look at it, and forgive me, but my brain just sort of shuts down and says, what trigger mechanism leads to that kind of a reaction to the sounds of someone outside of one's door? So how does a defense attorney try to move forward with a case like this?
It's so bizarre. Doesn't this remind you of the case with the former Olympian who shot into the bathroom door, killing his girlfriend because he claims that there was an intruder there?
Yeah, I mean, and that was even in another country, but we also have similar cases here in the United States. And the prevalence of the buzzwords "stand your ground," okay, castle doctrine, they have specific legal meanings, and they're not quite as absolute as a lot of people think they are, but they send a psychological message, rather, that, hey, look, I can stand my ground.
Right. Well, it has to be, in order for you to get that defense, of course, the behavior has to be reasonable. It certainly does in California. It's interesting. I don't know if a lot of people know this, but in Florida, vis-a-vis California, we don't have something called stand your ground, but you did mention it. We do have the castle doctrine that says if you're at your residence and somebody's going to use, you believe, a deadly force against you, you can immediately react in the same way.
Okay, the key there, of course, is that there's a reasonableness assessment that a jury has to look at it and say, look, if you reasonably believe that you are in deadly harm. I mean, if somebody breaks into my place with a weapon, comes after me, and I feel I need to basically kill the person to stop them, that's reasonable because I can articulate facts. Look, the guy crashed into the window. He was carrying a weapon. He said something. I didn't know who the guy was. I wasn't expecting anybody. He woke me up in the middle of the night. I mean, that would be something to articulate where a jury could look and say, okay, it's reasonable that, the defendant took an action to protect his or her own life. And a lot of times we have had cases like that, and of course prosecutors don't even bring charges because the defense would be so strong that the prosecutor and the police just look at it and say, yeah, that's what happened. This is not one of those cases, at least it doesn't seem that way to me.
No, it doesn't. That's why it might be a case of imperfect self-defense, which they would try to bring. Even in California, you can't have been the aggressor. It has to be reasonable. And although we don't have this specific stand your ground doctrine, we actually have it in our jury instructions. So we do. There is a sense of at your residence with the castle doctrine, but our jury instructions would allow a jury to allow a defendant to use deadly force were he to believe, without having to retreat, were he to believe that that was going to be used against him. So that's sort of part of our instructions. We allow it, but you can't be the initial aggressor. That can't work. It has to be reasonable. All these things that didn't really occur in this Florida case so much. So it's understandable that the prosecutor could get potentially a second-degree conviction out of this.
So let's talk about some of the evidence that we've seen come into court today. We've had some cell phone calls come into evidence, but we also had the gun used. It's a .44 caliber, and it was apparently found underneath the sofa in the defendant's apartment. It had
Correct.
3 spent rounds and 2 live rounds in it. So it seems to me that the evidence in this case is probably going to be forensics. We're going to have bullets matched up, that sort of thing. The bullets fired came from that gun. Therefore, there's a link. Is that enough?
Well, I mean, it certainly shows who the perpetrator was of the offense, and then we also have the statement that he made outside, saying he said, "I thought they were breaking in." He sort of mumbled under his breath. We have enough to show that he's the shooter. I think there's only evidence of the. I mean, I understand with respect to the spent rounds in the gun, but I think there's only evidence of one shot, if I'm not mistaken, that went from through. I believe it went through his door into the hallway, hitting the victim.
Yeah, I'm still waiting for them to piece that all together. The local reporters who initially covered this case back when it happened were, if I'm reading between the lines of their work, seemed to be a bit surprised that the criminal complaint basically didn't go into a lot of details here. So factually, it seems like the case is pretty clear-cut. Guy inside an apartment, woman outside the apartment, noise, shots fired. She winds up question of mental state, what the defendant reasonably thinking, was he reasonably fearful? It's characterization, it's not who done it, it's not a big factual question mark here.
Right, yeah, and that was sort of the issue in the beginning. That's why I believe they had the competency hearing with respect to the defendant. Is he competent to stand trial in this case? It's an interesting defendant. He's been through more than one defense counsel, and I've seen presentation calling it a conflict in front of the court, because sometimes either the defendant can't really help you or refuses to help you, assist you in the defense of their case, or they're just entirely difficult to work with, and it becomes impossible. It's hard to get off some of these cases, and sometimes you're stuck. So perhaps the first defense attorney is happy they're off the case, and now it's the state public defenders. But I've been involved in so many cases where I've been worried, is the judge going to allow me to get off this specific case? It can be for all kinds of reasons. It's something that just the public or the jurors sort of don't ever become aware of. It's an issue with being a defense attorney, how unruly clients can be, or clients might not pay you, and you may still be stuck on a case if you were there for enough proceedings. It's just sort of an interesting part of the practice that a lot of people don't know about.
Oh, yeah, of course. I mean, the true story of what goes on in these cases is in the attorney-client communication, and of course, we'll never see that, and for good reason. You know, if I had to hire you, Adam, and I'm not planning on getting in trouble in California anytime soon, but if I were, I guess I would have to give you a call.
Aaron, it's the business.
What's that?
Send me the business.
Okay. Well, you know, like I said, I'm not planning to get in trouble in California anytime soon. But, you know, look, I wouldn't want my communication with you to be all over the place for the government to basically be able to listen in on. That's part of the premise of the attorney-client privilege here. One has to wonder in this case what was said, you know, and how the attorney wrote up the particular case, because it doesn't seem to be a case with a really strong defense. It seems to be a case where a jury would look at it and say, come on, that was the wrong reaction. I mean, if somebody's trying to actually kick in your door, maybe. If somebody actually breached the door, okay, then we've got a totally different factual scenario. But to just pump lead through the door, the wall, whatever, upon hearing a sound, just doesn't sound like the sort of thing that a jury is going to reward.
Sure, and it sounds like the type of thing that a prosecutor would charge a second-degree murder count on. It's reckless. It's reasonably foreseeable by your reckless conduct that you can cause death or serious bodily injury, and that's precisely what occurred in this case.
We're apparently not going to be able to bring you back to the courtroom, you meaning the audience here, because we oftentimes run into this when we're out in rural areas. The signal gets a little bit wonky, so it's a big question mark as to how much more of this trial we're going to be able to bring you today. But in the meantime, we're going to shift gears very shortly and review some of the special segments that we had brought you throughout the week here. But in the meantime, Adam will kind of keep going and discussing this. So it seems like the case is moving along at a pretty good clip here. The witnesses have been short. The testimony has been frank. But that's to be expected in a case like this, like the Whaley case, where there aren't a lot of factual question marks. It's pretty clear who had the gun, who was injured, and what happened. It's a small scene. Involving a couple of people, not a lot going on in the periphery. It's not like it was a manhunt. It's not like it required police looking here, there, and everywhere, chasing down a suspect. It's a confined area. Is it not a surprise then that the case is moving along at a pretty good clip?
No, sure, it is what it is. There isn't a whole lot in this case, and you're not going to give a second-degree murder case to a green prosecutor. They're going to sort of push it through as fast as they can, and I'm assuming that the state public defender has experience with these kind of serious cases, and so I think that matters with respect to evidence can occur fairly quickly, and you know, the way judges are, they want these things cleared as fast as they can be cleared, so they'll try to get it done fast, I think, and we'll see what happens in the end. But there's really not a whole lot here, as you were saying. We know the basic facts, and maybe that's a lot of what you need to know. I doubt that we're going to be hearing from. One major issue, of course, is going to be whether or not we're going to hear from the defendant in this case to sort of create that imperfect self-defense claim. So that may take some additional time.
Yeah, I mean, the defendant's been pretty vocal up until this point. He's been writing letters to the judge. We've analyzed those a little bit here. And in some of the pretrial hearings, he was actually questioning the judge about his own charges. He's saying things like, well, it wasn't intentional, sir. And then the judge cut him off and said, wait a minute, I don't want you talking about this without your attorney present. So, you know, look, a wise judge trying to make sure that the defendant is represented before he starts saying things like that. You know, but if we're going to sit here and armchair quarterback the statement, is it a question of whether or not it was intentional or whether or not he really meant rather to injure that particular victim? Intentional act is just something that you mean for it to happen. An intentional firing of a gun versus an accidental firing, you drop it and it goes off or something. The defendant may have been misconstruing the actual technical meaning of the word intentional there. At least that's what it would seem at first blush.
Well, yeah, plenty of people do, and if they're not if they're not part of the justice system, what does the meaning of intent do? What does general intent mean? What does specific intent mean? These are things that sort of occur between the attorneys and the judges. But I was just thinking another source of delay. I mean, with respect to the way the defendant's been sending all these letters to the court and things like this, I could imagine, and since we're just armchair quarterbacking, sometimes it happens in the middle of the trial that the defendant says, "I want to represent myself." Who knows? The trial just started, and anything can happen, but usually judges don't allow that to occur sort of mid-trial, although you do have a right for self-representation even in the most serious cases.
Oh, yeah, certainly. One thing that did strike me, and I'm curious as to your opinion on this, Adam, is it a bit bizarre that we're seeing this case start this week right before the holidays?
Well, I think they can probably hammer it out, and everyone can have their vacation. But you would be surprised, though. In so many courts, so many judges, if they don't have a vacation, they'll have court dates all the way until the 24th. They'll maybe have a full calendar ready to go. Afterwards, their schedule is not your schedule, and you'd be surprised, how they want to fit things into what sort of holidays and time frames. It's always shocking to everybody.
Yeah, exactly. It surprised me that this started at this point, but again, they seem to be moving through things relatively quickly. So, Adam, I know you're going to stick around with us for a little while, but being that we are having some trouble with the signal coming out of Iowa, we're going to switch gears and bring you a segment that